Hello, you are listening to the Divorce University online podcast with your hosts, Thomas and Tammy Ferreira.
Hi, I'm Tammy.
And I'm Thomas.
And today we're going to talk about appeals. So we're going to let Thomas lead this. And let's just say, I want to say right at the outset, Thomas is licensed in California. Okay, so doesn't work the same in every state, has some similarities, but wherever you are, if you want to do an appeal,
you should talk really fast when you say that. Thomas Ferreira is not licensed in the state of California.
No, I want him to actually understand me.
Oh, okay.
So you need to talk to a local practitioner because laws are different in every state. But we're going to kind of talk about some general concepts about appeals based on Thomas's experience.
Right. Okay. So you get you go to a family law trial or a family law request for order, and things don't go the way you thought. Things are go poorly, and you want to know. The order gets, she gets full custody or whatever, and you want to go, well, shoot, what can I do? This order is a disaster. And so you call your attorney, and the attorney says, well, this is a final order. There's nothing you can do. And your question is, well, can we appeal? And the answer in every case is yes, you can appeal. The question is, should you appeal? So that's really what I want to talk about is, when is it a good idea to appeal? And then to a certain later, I want to talk about how do you make a record for appeal?
Well, and let me just say too here at the outset that appeals are a very unique
specialty.
That's a good word for it. And there are there's we know a handful of people that specialize in only appeals, which is also a little bit rare. Thomas has done them and knows how to do them and has done a few family law ones, but actually most family lawyers don't even know.
I have a pretty good record, actually.
Yeah, because you know when it should be. You have a pretty good sense of when it will succeed and when it won't.
Appellate work is a lot more common in workers' comp where I used to practice.
Right.
And so I had a fair amount of success in the courts of appeals, and it's just something I enjoy doing.
Yeah, because it takes a lot of brainiac.
Yeah, it's a brainiac thing.
Yeah,
definitely.
And so, we had a case a few years ago where Thomas filed an appeal on behalf of our client, and the other attorney didn't even know the proper procedure for responding, the other family law attorney, because they had never done an appeal before. And so it is a very unique thing.
Right. So just to go over the basics, most cases, the vast majority of cases are decided at the trial level. And when I say the trial court, I don't mean that you have to have had a trial. Sometimes it's a motion, but we refer to the lowest court collectively as the trial court.
And in California, that's the Superior Court, is what we refer to it as.
Oddly, in New York, it's the Supreme Court.
The trial court is
the trial court is called the Supreme Court of New York. Yes, it is.
That's odd.
Yeah, so you've got Superior Court here in California, and I think that's pretty common throughout America is that we have the Supreme Court is the trial court.
Well, I think I'm sorry, let me just say, I know in a lot of other places where I have clients and things, there's like the district court. They'll call it district court. There's another name I'm trying to think of for it, but I've actually found a lot of
court.
Circuit court, yes. Yes, circuit court, district court. It's like, what's the difference in all those? Are those all? Does that all mean Superior Court? Is it all the same thing?
Yeah. Well, it depends. If the initial judge that makes the decision is in the trial court, and I'm going to refer to it as the trial court.
Okay.
So if you're in front of the trial court in family law cases, we don't have juries.
Right.
So it's a judge trial basically, or a judge hearing. And then the judge issues an order, and that order is final. Once that judge states the order from the bench, it's final. Now, we have tiers of courts. So above the trial court, we have a court of appeal. In California, it's called the Court of Appeal. And we have my county is in the 4th district. I used to practice in the 2nd district because I was in LA County, but we're in the 4th district. And then above the statewide Court of Appeals, you'll have maybe 10 or 11 divisions of it across the state. There's a Supreme Court.
So what's the Supreme Court called in New York if the Superior Court is called the Supreme Court?
You know, that'd be something to look up. That'd be something to look up. I think it's like the Court of Appeal something. Or
Times 2?
Yeah.
Squared?
The really big Court of Appeal. So you have the Supreme Court, and then every state has a Supreme Court. Okay, so what can a trial court do? The trial court hears the evidence, weighs the evidence, applies the evidence to the law or the facts that it finds to the law, and renders a decision. Okay, and people think, well, if I don't like my decision from the trial court, I can just appeal. Okay. And that's where you'd be wrong, because the appeals court only has the power to consider certain very narrow issues related to the trial court. The Court of Appeal is not a do-over. It's not, the Court of Appeal can't reweigh the evidence. In California, the standard for the Court of Appeal is that they, for most issues in family law, it's abuse of discretion. So in order to win in the Court of Appeal, you have to show that the court abused its discretion. Like, for example, the court made a child support order, but did not follow the statewide guidelines. Okay. The court has some discretion in the child support, but they have to follow the guidelines. So that's an appealable issue. Or in, say, a domestic violence case, the standard is abuse of discretion. Let's say that the facts of the case are that the parties yelled at each other at a transition, and then nothing else happened. The Court of Appeal could find that it's an abuse of discretion on those facts, to find that domestic violence occurred, depending on what it is. There can be verbal, but by and large, it's pretty hard to get a domestic violence order if there hasn't been any physical contact, if there hasn't been any threats of violence, in that kind of thing. If it's just, the usual transition point conflict, it's very hard to get. So in that situation, if you didn't get your domestic violence restraining order, you probably would not have a good appeal, because the court has discretion. The court can decide. And the Court of Appeal is not allowed by law to second guess that trial court's decision.
Right.
Okay. The other way you can win on appeal is a mistake of law. In other words, the lower court, the trial court, has to follow the law. Okay. For example, in California, we have Family Code Section 3040, which is, or 3042. I can't remember. It's the section that says if there's a finding of domestic violence from the court, there's a presumption against the party that committed the violance.
3044.
3044. Thank you. See, I was off. You're getting closer. I was getting.
Go by twos. 3040, 3042, 3044.
Right. It's a 3044 presumption, and it's pretty black and white when you read the statute. And many cases have been reversed on appeal because trial courts want to give that domestic violence perpetrator joint custody in some form, and they just can't do it. So if the trial court says, well, he seems like a nice guy and he's real sorry that he did it, the court has to apply the presumption And there are certain things that rebut the presumption. There are certain things that don't rebut the presumption, but they're all in the statute. So if the court doesn't follow the law, you have a good appeal.
So what happens if you feel like the court, like you presented certain evidence that you feel like the court didn't really consider? Because I think this is a complaint I get a lot.
Right.
Is and it's interesting because a lot of times I find that judges read everything, but they don't comment on everything individually. They don't go through and go, this piece of evidence is good, this piece of evidence is bad, this piece of evidence favors mom, this piece of evidence favors dad. That's sort of almost what we're looking for, the satisfaction we're looking for from the court that we don't get. But what if you have some pieces of evidence that you feel like were significant, but you don't think the court considered? Is that a good appealable issue?
No.
Why not?
Okay. First of all, a lot of hearings and trials take place without court reporters. So for one thing, you need to have had a court reporter there to see what the court considered. But the Court of Appeal is going to assume that the court considered it if it was offered and accepted into evidence. So if you have a declaration that says, Dad was off drinking and partying, and the court didn't consider that evidence, but it was heard in the record, the Court of Appeal will assume that it was considered.
Gotcha. So if it was put in front of the judge, they assume it was considered. And a lot of the problems with appeals is that you need all this documentation in advance while it's happening. And yet you don't always know that that's going to be a thing that you want to appeal. I mean, when you start getting into really expensive cases and really premium services for clients and all that kind of thing, there are law firms that will say I want a court reporter at every single hearing. You hire them, you pay extra for that to be there. At least in California, we do.
Right, and it's not cheap. It's like $800 for a day of trial, or over $1,000 now with inflation.
Or even if you want them there for an RFO, they might have to sit and wait for 3 hours to be your court reporter, and it's costing you $300-400 bucks every time you go to court just to have them there. So you also need to ask for a statement of decision from the court, right?
Right. Yeah. In California, we have this thing called a statement of decision. I couldn't tell you that they have this requirement in other states, but to get a statement of decision, you have to ask for it. And what a statement of decision is, it details the court's legal reasoning as to how they reached the decision, and then the pieces of evidence they relied on for each legal element of whatever you're litigating.
And how and when do you ask for that?
Well, in California, you have to ask for a statement of decision in advance on any case that is less than 1 day of hearing. So if it's less than 1 day, then you have to ask for it on the day of the hearing or before that. Generally, I do a written request.
So you'll put it into your request for order, your FL300, as like an other box and say statement of decision requested on all issues.
You could do that way. I usually do a separate pleading. So I do, request for statement of decision. And basically what I do is I set forth my theory of the case, and I say, I want a statement of decision on, for example, what exact conduct did the court consider constituted domestic violence? What evidence did the court consider in awarding custody? What were the certain pieces of evidence that led to the finding that the best interest of the child was, mother having full custody or whatever it is?
Right.
And I list those in a pleading, and I file that with the court.
So if you disagree with so let me ask you this. If you disagree with the judge's decision, and this may be a California only thing too, I'm not sure, But I know a lot of people also, I know that they do this in other states because I've heard other people talk about it in other states too. But what's the difference between appealing and doing a motion to reconsider?
All right. In California, we have a motion for a new trial, and procedurally, it's very complex. You have to have, I think there has to be a declaration from the person requesting it, and there are very draconian timelines that this has to be filed under. Generally, if you're 10 days out, you forget it. It's not going to happen. But the court is only going to make a finding that a new trial is necessary if there's some new evidence that you just discovered. If you could have offered the evidence and didn't, they're not going to grant that. And usually it's something that occurred between the time of the hearing and the time that you make the filing. It's new evidence that newly discovered.
So it's like you leave the courtroom with, let's just say I'm mom and I leave the courtroom and dad's got full custody, and then 2 days later dad gets a DUI, then that would be a good motion to reconsider because it's new evidence?
Yeah, possibly. Or even if it occurred before, like say you find out.
Oh, he had a DUI the night before the hearing, but he didn't mention it.
Right. And you didn't know because discovery was closed, and you have an excuse for not having presented that. Gotcha. Because a reasonable person would not have known that going into the trial.
So a motion for reconsideration.
It's newly discovered evidence.
So motion for reconsideration is really based on some new piece of evidence.
It can be. Or it can be some error by the judge, or,
well, I guess what I'm trying to determine is, how do you know if it's reconsideration versus appeal? What are the differences between those two issues?
Well, generally the appeal is available anytime you have a final order. So the order is final. It's, like I said, as soon as it's issued from the bench, it's final. I would say that mostly the petitions for a new trial is some irregularity in the trial procedure, or
but if
admission of evidence, or newly discovered evidence.
And I know you're saying trial, but you mean even in a regular RFO?
Yeah, in a request for order or a motion hearing for those of
people not in California.
Yeah, or order to show cause, it's known as sometimes.
Yeah.
The shorter hearings where they make decisions based on declarations.
So really, for a motion to reconsider on one of the regular short hearings is usually based on some new piece of evidence.
Yeah, and I wouldn't even bother. It's not. It's an expensive procedure, and it's almost never granted.
Same with appeals, right?
Right. Well, the appeal, though, has to do with a final order. So let's say that you get a support order, for example, is a good example. So the court has a 20-minute hearing, and it issues a temporary support order. That order is appealable because it's final. It's a final temporary order, if that makes sense.
That's so confusing.
Yeah.
So I'm not sure I even understand. And
it's final because it adjudicates the rights of the parties. Yes, you can still modify the temporary, but you have to, there has to be another hearing.
Well, I guess what's confusing to me is, if the court didn't issue an order, what would you be appealing anyway? Like, there has to be some order out of the court.
Well, you appeal if you appeal the court not issuing an order if you're the proponent of the order. The court has to make a final adjudication of the rights and responsibilities of the parties, and then you can do an appeal.
Okay, so let me go back to my first question, because I don't think I understand. And if and I'm not trying to be difficult. I'm just telling you that if I'm struggling to understand,
why are you trying to be so difficult?
Other people are struggling to understand too. What determines whether you should file a motion to reconsider versus an appeal? What's the difference between those two things?
Well, I would say that both remedies are fairly unlikely to be granted.
Okay.
But the appeal has to be for a final order. That's the rule. It has to be an order that what constitutes a final order is
Right. It's a little more complicated.
it's
but essentially,
complicated.
most orders are final orders. But a motion to reconsider can be either a final order or not. Is that what you're saying?
Yes. It can be anything that was, it can be in a
All right,
jury
so
situation, you can ask for a new trial.
Let's hypothetically say we have a final order.
I would say just forget about the motion for a new trial. I wouldn't even,
Motion to reconsider?
It is so rare that I've never done one. How's that?
I see a lot of people do these. Is why I'm asking. A lot of my moms, and especially in other, I see a lot of people wanting to file a motion to reconsider. I think it's a big thing, and that's
have you
why
ever
I'm
seen
asking.
one successful?
I have not seen one successful, but it's still people file them, and so that's why I'm kind of grilling you on them a little bit. So let's just bear with me for a second. Let's say hypothetically it's a final order. I can do a motion to reconsider or an appeal. How do I determine which one of those is the most applicable? Talk to a lawyer. I don't know. Maybe there's no good answer to that. I guess your answer is it depends.
Right.
It depends on the situation.
Yeah.
But what I understood you to say is appeals have more to do with like procedural things where they didn't apply the law correctly, and motions to reconsider have more to do with like there's some new evidence, new something that wasn't presented at the time.
We're getting really technical. But
Okay.
Let me just say that, there are two grounds essentially for appeal. One of them is abuse of discretion, which means that you look at the evidence and you say there's no way based on this evidence that a court could have made this finding. The court is abusing its discretion. And the other thing is kind of a mistake of law, or there wasn't any evidence presented on an element of your complaint. Like a good example might be imputation of income. So to impute income to somebody, you need to show that there's two elements. That you have to show that there's a job available for this person in the market, and you also have to show that the person was qualified for the job. And if you don't have evidence on both of those, then the petitioner or the moving party should lose. All right. If it's granted under those circumstances, you might have a valid appeal. And so it's either.
And really what I was trying to get you to expound on more was the motion to reconsider, because I think what happens is people know that appeals are frequently denied, and they know they're very expensive and they're very difficult, and they go to the thing and they try to look it up and they think, I don't understand what any of this means. I don't know. I can't do an appeal. Oh, but hey, motion to reconsider. Okay, that's similar to a motion. I can do that. No problem. I probably could name 10 coaching people that I've talked to in the last year that have done a motion to reconsider.
Right.
Which is why I'm asking you to kind of explain.
Well, you're going in front of the same judge.
That's what I always say. You're going to go tell the judge they were wrong? Oh, that's probably going to end well.
Right. And it's not, there's no do-overs.
Right.
If you screw up at trial, then, your attorney's in malpractice. I don't know.
Or you as your own attorney. Yeah, it's like the guy in Riverside who kept filing the same motion, and the court said, how many times are you going to file this? And he said, as many times as it takes.
Yeah. Basically, there's no do-over. You can't just go, well, this is the wrong result. I want a do-over.
Right.
And then you go in front of the same judge. No, the award or the finding of the judge is final.
Right.
Okay, so your only option is to appeal. Now, when you decide whether to appeal, it's not based on did the judge get it wrong based on how they weighed the evidence.
Right.
The standard is, could any judge have reasonably made this finding based on the evidence?
Right.
The court of appeal does not second guess the decision of the trial court.
Right.
It only decides, could a reasonable court have even made that finding? Does that clarify it?
Yeah, a little bit. And that's why appeals have such a high deniability thing, right? But I do think that the motion to reconsider, for a lot of people, it is like, well, I think the judge was wrong. And then they want to file a motion to reconsider. And a lot of times I find myself like trying to help them understand.
It's a waste of money most of the time.
Well, an effort. A lot of them are self-represented people
Right.
that do this. And because an attorney's going to tell you, no, I'm not filing that.
Right.
But the people that are self-represented try it a lot because they think that the court got it wrong. And it's hard to kind of explain to somebody, this is this.
Well, do you have something new? I mean,
Right.
to present, or are you just going to put the same old evidence behind
Right.
by them?
Right. Yeah, and a lot of times that answer is, well, it was there, but I don't think they considered it.
Yeah, no, you don't have grounds. You could even end up paying the other side's attorney's fee in that situation,
Right.
for filing a frivolous motion.
Yeah. All right. Well, thank you for that. This is a really complex subject, and this is not, the problem with these types of situations is every single one of them is nuanced. Every single one of them is complicated. That's why we're always telling you, if you're going to deal with some type of appeal or motion to reconsider or something, you really should consult with a local attorney and decide if you even have a basis for even bringing that before you put yourself through all the grief, all the energy, all the cost. And I find one of the biggest mistakes we make as divorcing people is we pour a lot of energy into fighting with the other person.
Right.
And honestly, even if you could get an appeal, even if you could succeed on a motion to reconsider, it's not as simple as will it work. You have to consider the intangibles. You have to consider collateral damage. You have to consider the cost to your family, the cost to your children. Not everything is about just black and white, how much money will it cost me or will I win? It's a lot more complex than that. And making that assessment depends on you and your family values. So it's helpful to consult with somebody and take a step back from it.
Right. And I think when people get findings from the court, particularly adverse findings, they're biased. You're biased. You think, oh, this judge couldn't have done that. And I hear that all the time. Obviously they weren't listening, or how could they do this? Or obviously they're biased against me, or, maybe there's some racial component or some discrimination going on or something. And I find that's almost never the case. Okay. Because you got that decision, you feel like you got screwed.
Right.
Okay. And I'm here to tell you, everybody in family court feels like they got screwed. Everybody does.
Yeah.
You're saying, oh my gosh, he got 50-50. That's the wrong decision. And he's over there going, I can't believe that the court gave her parenting time, how crazy she is.
Right. Right. We've all got our own version.
We're all biased in favor. And
Yeah.
and the thing is, the Court of Appeal is, it's like a law. It's like law school. The Court of Appeal sits up there and makes legal decisions. They don't care to a great extent what the facts were at the trial level.
Right.
It's important, but they're not sifting through, well, was the court justified in believing Jane Smith's testimony? They're just not going to do that. They're not going to reweigh the evidence.
Right.
What they're going to do is they're going to determine, could a trier of fact, could any judge or any jury have possibly found that the requirements of this law were met?
Right.
And was the law correctly applied? Was the statute correctly interpreted? In appeals, we do a lot of statutory interpretation, like, what does the term best interest of the child mean?
Right.
What's the meaning of it? And there's usually a line of appellate cases that will tell you that.
Right.
And it's usually pretty well settled in a thing like as common as that. But they're not going to reweigh it. They're going to apply kind of an intellectual. They're going to go to the books.
Right. Right.
They're going to look up the past cases.
Yeah. And I think like you had an appeal that succeeded a few years ago. And I think that's why, because you knew going in, like, this application of this part of the law was completely wrong. Right. In your opinion, at least. And then you did the appeal and the appellate court agreed with you. Right. So now
there are situations where you can get an appeal before a final order, and I've actually done this. It's called a writ. Or in California, it's called a petition for writ of review, or mandamus, or whatever the Latin phrase is in your state. But essentially, the case that I handled was a case where I went to court at a review hearing, and something happened at the review hearing that I was totally not expecting. I started to make the argument, and it was a case where parental alienation was being alleged. And I had the mom. We were denying the parental alienation.
Right.
And the court was, for whatever reason, the judge was convinced that parental alienation had occurred. So during a review hearing, and without receiving any testimony or evidence, the court just awarded dad full custody. And we're sitting there with our jaws dropped all the way onto the table going, that's not right. And since it was a temporary custody order, it wasn't final. It wasn't ripe for appeal.
Right.
So what do? And part of the problem was now you have two teenagers who are refusing to go to dad's, that the cops are going to come in and enforce this order. So it's an emergency situation.
Right.
So we have this emergency procedure at the Court of Appeal. And basically what I said is, this person had a constitutional right to due process of law before they took her custody away.
Right.
The trial judge did not give her due process.
Right.
So the court should reverse this order. And the court agreed.
Right.
And it was a particularly egregious situation.
Yeah.
That involved an emergency. I have filed a lot of writs because it's a very common thing in workers' compensation for reasons I don't want to get into.
Right.
But the 99.9% of emergency writs are denied. And they don't even tell you why. They just send you a postcard. It says, writ denied. Remember the one we did?
I do.
Yeah.
I do.
And it was it was on 8.5 by 11 pages. And there were 2 words above the Court of Appeal panel's opinion. And it said, writ denied.
Yeah. Yeah.
Shoot.
And I'm like, what is this? He's like, that's all you get. I'm like,
And
what?
you spent
hours, days, pouring yourself into it.
I probably spent 40 hours on that thing.
Yeah. Writ denied.
Writ denied. It's like, wow, did I shave my legs for this?
Very unsatisfactory. Yeah. Appeals and motions to reconsider are have a very high deny rate, and they're really complex and difficult and expensive, and it's just hard. I find most of the time people if it were me in that situation, I'd rather just pour myself into the long-term change than to trying to get some immediate shift. The immediate shift is hard.
Yeah. If you're confused about whether to appeal, you can do one of our strategy sessions, and I'll give you my opinion.
Yeah.
Usually it's don't bother. Okay.
So be prepared for that.
I mean, sometimes you have this really juicy legal issue where there's statutory interpretation. I had one of those.
Yeah.
I did a writ in a workers' compensation case, and the case that I handled still stands for a major point of law on how what was then called the new law or the Reform Act. It was in 19. I want to say it was in the late 90s, because the statute was amended in 1991 to have this requirement. And the whole thing was over how that statute was interpreted. And I read the statute, and it was obvious that this court had interpreted the statute incorrectly.
That's the case that went to the Supreme Court.
And it went all the way to the California Supreme Court, and I won. The Court of Appeal, by the way, affirmed the trial court. So if I had stopped at the Court of Appeal, I would have lost.
Huh.
Yeah.
And you appealed to the Supreme Court after the Court of Appeal denied you.
I sure did.
Wow.
Yes, it was really cool. It's like one of the highlights of my career. But the thing is,
that was BT before Tammy.
Yes. And the thing is, to me, the appeal was obvious. It was obvious that the appeals board had misinterpreted the statute.
Right.
But the Court of Appeal affirmed because the Court of Appeal was giving so much deference to the trial court.
Yeah. So you had to go one level higher.
Yeah.
Yeah.
It's very, 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 very unusual.
Yeah, it's all very complex. My head really swims around this kind of topic, which is why I wanted to kind of, hopefully we didn't leave you more confused. Hopefully we leave you with a little bit of better understanding of it. It's a really, really complex topic.
I can summarize just really quick.
Okay,
Look,
go.
if you don't have something new, don't ask for reconsideration. And in fact, don't ask for reconsideration in the vast, vast, vast majority of cases. Right. Number two, unless the trial court really, really screwed up the law or made a decision that's so far out in left field that you just scratch your head, you probably don't have a good appeal.
Yeah. All right. And as always, consult your local attorney on these types of issues because they are super, super complex. All right. So if you are listening to the podcast, don't forget to rate and review us and also subscribe so you get notified as new episodes come out each week. If you're watching us on YouTube, hit like below this video and also subscribe to the channel so you get notified as new episodes are released each week. If you would like to join mine or Thomas's Facebook group for parents, moms and dads, he has one for dads. I have one for moms. You can go to facebook.com/groups. Mine is /custody for moms and Thomas's is /custody for dads. Those are our two free Facebook groups. And thanks for joining us.
Bye-bye.
Thank you for listening to the Divorce University online podcast with your hosts, Thomas and Tammy Ferreira. For more information, visit www.divorceuniversityonline.com.